Yes.
Welcome to the session. Welcome to the session. Welcome to the session. Welcome. So to have a very fruitful session. Thank you.
A very warm afternoon to, am I audible? A very warm, yes, a very warm afternoon to everyone present here. My name is Amruta Saranya, and with me, I have my co-conciliator for today's session, Ms. Aarti. At the outset, I would like to clear that we both are certified conciliators and have about 10 years of experience in this field. So I hope everyone is healthy, maybe not so happy, but have had your lunch and ready to settle the dispute at hand amicably. Firstly, I would like to thank both the parties for committing to the session, especially on a weekend, that too a Saturday. I know this might not be the most ideal day to settle the dispute, but your commitment shows that you are willing to resolve it. And let's take that momentum forward. So just so that we know who is who, maybe we can go around with a little set of introduction where I request all the members in the room to just introduce yourself. That will only include your name and the authority you are representing. Also, an additional question for the client would be if they have the requisite authority to take decisions from whom they are being present here today. Please note that this is not your opening statements, just your names. And by virtue of customary practice, the requesting party is supposed to start.
First of all, greetings to everyone. My name is Shayad. I am the leader of the trade union that was being formed by around the Sabha trade union, and I do assure you that I have the authority that to reach to a conclusion amicably, which we enter into today. And with that being said, my counsel will be introduced.
Thank you, Saya. So, I am Jay Gupta, and today I am representing my client, Saya. So, I am an advocate at Karnataka High Court, and I have a 10 years of experience in arbitration and conciliation. Previously I've represented many clients in conciliation session, in mediation sessions, and I think this session is going to be one of the great sessions where we will be able to reach to amicable solution.
Thank you, Party. Who do we have from the other side today?
Esteemed conciliators and respected members from the trade union. My name is Arya Shrivastava. Please refer to me as Arya. I'm the legal counsel on behalf of ACPL, a dear friend of mine, Ms. Dhanyavad. I have an experience in labor disputes, quite a lot of experience, but be rest assured, I do not hold any decision-making power. I'm merely for legal guidance, and that is all.
Greetings to everyone present over here, esteemed conciliators and the representatives from Aramco Sabha Trade Union. Well, I am Ms. Dhanyavad, the CEO of Aramco Commerce Private Limited Company, and I am here to clarify the situation that has arisen recently regarding the dispute between both the parties, as you all know about. You can refer to me as Dhanya, and I hold all the decision-making power on behalf of the firm. Thank you.
Thank you, Party. So, having done with the introduction, a small suggestion from my side would be that since this session is going to last for 75 minutes, it is a small suggestion that you make use of the water bottle kept beside you. So I would like to roughly give you the key features of the conciliation. I am very sure that the counsel would have briefed your clients, but as conciliators, it is our duty to let you know. Firstly, by seeing the faces of both the parties, it is clear that this issue is very important to you, and thus confidentiality becomes the most key feature. Please be assured that anything said within these four walls of the room will stay inside and not go outside. So do not shy away from putting out more information. That will help us resolve the dispute. Secondly, the feature is voluntary. You have come here voluntarily and you have the authority to exit voluntarily with any kind of solution that you may arrive at today. And thirdly, today's session will be non-prejudicial. In the sense, anything that you state today will not and cannot be used against you in any court of law. With that, I would like to give an analogy of what conciliation means to me, and then I will pass the floor to my madam co-conciliator. So, for me personally, in my free time, I play guitar. And conciliation process is like playing guitar. What do we all know about the basics? For guitar, you need two hands. Correct? All of us agree on it. And only when the two hands work together can a beautiful music be produced. But if they do not cooperate or refuse to cooperate with each other, the music so produced may not be ideal and it is not very harmonious to listen to. So thus, you two, Mr. Shah and Ms. Dhanya, are the two hands who are vested with the responsibility to work together. So, however, like we try a lot, but sometimes the music is not so good because the strings are out of tune. That is where we both, as conciliators, will step in and play the role of a guitar tuner for you to bring you back to the process. With this, I will pass on the floor to my co-conciliator.
Thank you, Madam Co-Conciliator, for such a wonderful opening to the session. Again, greetings of the day to both parties present here. I'd like to very humbly welcome both of you. And I really appreciate your efforts to sit before us here and take an initiative in communicating and reaching some sort of a settlement to this particular matter. We as conciliators have been appointed under Section 43, subsection 1 of the Industrial Relations Code, is what I just wanted to make clear to both the parties. Now, very quickly and not taking much of the time of the process, let me brief both the parties regarding our role as conciliators here today, followed by the format of today's session. Is that all right?
Yes.
All right, great. Now, under the Arbitration and Conciliation Act, what our role is as a conciliator is merely to mediate the dispute which has arisen between the two parties, namely the requesting party, which is the Aram Karo Sabha, the trade union, and the responding party, which is Aram Commerce Private Limited. Now, in lieu of the same, kindly keep this in mind. We are mere access to the wheels of your decision making. We are only going to encourage you both in a way that you come to some sort of a common consensus so that this issue can be resolved. All right. Moving on, let me clarify it to both parties that neither me or my co-conciliator have any sort of a conflict of interest within this matter, nor is it that we prefer any one party over the other. So you can rest assured, whatever is going to happen here in this hall is going to be completely fair, just, and in compliance with the objects as set by law of fairness. Now, very quickly, I'd just like to caution the parties regarding one thing before I proceed to explaining the format. As per the Arbitration and Conciliation Act, again, whatever is the subject matter of today's proceedings cannot be a simultaneous subject matter of any judicial or arbitral proceedings. Kindly keep that in mind. Now, coming to the format, both parties, beginning with the requesting party, followed by the responding party, will have 4 minutes of time to speak about their opening statement. I very strongly suggest both parties to limit yourself and consider the paucity of time because we want all of your concerns to be heard. Following that, we will delve into the main conciliation and negotiation session, wherein both parties will be given equal chances and opportunities to elaborate upon them. Following that, if a deadlock situation does emerge, right, we will be requesting or suggesting a private caucus to both parties, wherein one party will be sitting with us, the other party will move out. We will discuss certain things with the other party. In the private caucus, you can share any confidential information that you wish not to reveal before the other party or any other concerns that you have. Similarly, after you go, the other party will be got separately. This will basically give us as conciliators an idea regarding what are the actual concerns, expectations, and what is the root cause of this particular dispute. All right. If I am clear, and if everything is set in motion and there are no questions from the requesting or the responding party, I would like to hand over to my co-conciliator here to call for opening statements.
Thank you, parties. Just to add 2 lines, like she already mentioned, we do not have any conflict of interest, and I can confirm that none of us have met the parties personally. Correct? I can see the nodding heads. Thank you, parties. So, just before we begin, 2-3 ground rules that we have to establish. Number 1, no crosstalk. Since we know that it is a collaborative session, it is preferred that one party speaks at a single point of time. Secondly, please keep in mind that whatever has happened is happened, but solution is the key. While you defend your stance, it is also necessary to provide sufficient solution to resolve the dispute. I hope all the parties are clear with this. Thank you, parties. It is now time for your opening
Madam
statement.
Conciliator?
Yes.
Could I just add something,
Yes,
Madam
yes.
Conciliator? just for the information of both parties, I would suggest both parties to address the other through the conciliator. So you would not be directly talking to each other. You will be addressing us, and through us, you will be addressing the other party. Please keep this. Thank you. I'd like to request the requesting party now, as is the norm, to begin with the opening statement, considering the paucity of time.
Greetings once again to everyone, to the conciliators as well as the responding party, client and counsel. First of all, I would like to thank both the conciliators, Saranya and Arya, for beautifully explaining the process of conciliation as well as the ground rules of conciliation. And additionally, the conciliator one who brought an analogy of guitar, and we promised that we will be one hand of that guitar, and we are expecting the same to be other hand from the other client as well. So that being said, though my counsel Jai has already explained the process and ground rules of this conciliation, but a sort of your opening statement was sort of bit of refresher for me as we just entered into it. So coming to our perspective, why we are here, we are the delivery persons, and I am the person representing the trade union of champions as named by the company. There was a company, Aram Karo, which was a delivery app, and which was launched in January 2020 by Aram Commerce Private Limited, and everything was going fine between the company and the delivery personnel, because the main concern where it came was in 2022, I guess, in 2022, where we tried to raise our concerns to management, top management, but that went unnoticed. After that, seeing this situation, we tried to form an union so that we will have collective bargaining power, so that we can have our rights being heard. But when we tried to form a trade union, there was a threat from the company saying that whoever were involved in the unionization efforts will be terminated. And despite that, I went ahead and formed a trade union. After that, in June, the main concern and the boiling point of this issue came when in 2024, I remember it's June 12, 2024, when CEO of the company, Dhanyavad, organized a virtual Zoom meeting with 120 champions. The meeting was termed as appraisal and team management. Everyone of our champions was very happy. And
I'm sorry, Mr. Shaya, to interrupt you, but we are already aware of the facts of the case. Could you please give a brief?
We are just letting our feelings know that how we are feeling now,
Indeed,
so that we can set the agenda for the tone, right?
Yes. I would just suggest you to limit yourself to the demands that you have in brevity.
Yeah. Just 30 to 40 seconds, I would like to come and I would like to hand over to my counsel. The main purpose, and after that meeting, 120 employees will be terminated. I understand thinking of them will make me feel very bad. Like, I see them from a very close perspective from the ground reality. If you see them, if I should say where they are now, they are on the roads right now. They don't have any, as they come from low income families, so they don't have any sort of money, don't have any sort of living right now. The main concern of me forming this trade union was to help the company and to get more profits to the company by hearing our grievances, so that we can work more effectively. There was nowhere our intention to do strikes, to go against the company, because we always consider them as our family. We always consider them as our family, and we always consider the CEO Dhanyavad as a father for God for us, because he is the one who gives us monthly salaries and everything. With that being said, we would like to hear what CEO, like how we treated him as a god, and we would like to hear from them, and we are open to negotiations. And I would like to say that we, the trade union, are looking forward to positively iron out the differences that unfortunately occurred between our both companies, and we would like to say that we are open and flexible. With that being said, Jai is my counsel. He is not only the counsel of mine, but a very best friend of mine, me from 18 years. And with that being said, and he will not only be playing a role of a council today, but also a role more than a council. He will be assisting me in the technical matters as well. With that being said, I would like to pass the job on to my council.
Mr. Jay, again, I'm sorry to interrupt, but due to the paucity of time, as Mr. Shayad has already given us an overview of his emotions as well as the concerns, kindly limit yourselves to 30 seconds to 1 minute.
Sure. Firstly, I would like to thank both the conciliators for their wonderful statement and explaining the rules and regulations, and to the Mr. CEO Dhandyawad and to this council for accepting our invite for the conciliation session. And I know it's already 3 p.m. and as Madam Conciliator already told me to be very vivid and it's concise. So, as you know, I am the counsel for Mr. Sahya. I am purely an advisory in nature. I will be advocating my client's rights at this table. And moreover, as my client have already stated, he is my friend. So he has given the jargon to me to explain what he is feeling, what his members are feeling. So coming, like I'm just concisely as per your demand, what are his concerns are. As he already stated, what problems he and his trade union members are facing. First of the problem that he has pointed out is that the termination. We wanted to discuss termination as the first schedule because those 120 members are being terminated without giving any valid notice, without giving any valid reason. And again, as a second sub-agenda, we want to talk about the wages and overtime pay. And thirdly, we want to talk about the job security. And fourthly, we want to talk about the grievance redressal system. And with that said, I think this conciliation session is going to be very fruitful. And I'm expecting the same as Madam Conciliator work. And my client have already stated we will be one of the acts who will play a beautiful note on a guitar, and we are expecting the same from the responding parties.
Thank you, Party. The responding party can begin with your opening statements and set your agendas that you propose.
First of all, thank you to both the conciliators for joining us today on a Saturday. Managed to get both the parties here, that's commendable. This really presents to us a vital opportunity to come to a common ground. And as the parties have already mentioned, they are open to change and they're open to compromise. So I hope that remains the truth and the actual case throughout the conciliation proceeding. My client and I are here to address all your concerns openly. We have taken note of your agendas. However, at the outset, I just want to set these straight on the record that the layoff, that the termination of the layoff that the respected council has spoken about was not contravening the law, so it was not illegal per se. And the strike which has been going on, I hope it is called off pursuant to the Industrial Disputes Act, since it is not allowed during the conciliation proceedings. Madam Conciliator, yes, confirm that.
I hope the strike is not ongoing right now because a strike cannot happen during a conciliation proceeding and 14 days after. Perfect.
Thank you so much. That's really appreciated. And I just want to set straight the status. All the champions who are close to us, they're dear to us, but they are not employees. It does not mean that we do not value them. They are contract-based gig workers. And I've taken note of all the agendas. Please allow my client to go ahead and share his views.
Once again, greetings to everyone. I would like to extend my gratitude towards the conciliators for setting the tone nicely towards the conciliation proceeding. So before I begin, I would like to just give an overview about the precursor to the dispute. So as you all know that Aramco, we started this company back in 2020, and it was one of the revolutionary steps taken by us to meet the on-demand delivery sector, to cater the on-demand delivery sector of food or any sort of utility services, both in the rural as well as urban areas. Now, over the years, we have grown substantially, but due to the recent economic downturn, we have faced certain revenue challenges in terms of money. And on June 12, 2024, we took a decision to terminate 120 of the employees, of our employees, not the employees, but the gig workers, the champions. And we highly regret this decision was interpreted as abrupt or impersonal, as we hold our champions more than the family. And I personally, on behalf of the company, I'm aware of all the allegations that have been made against me as well as my company. And I'm more than happy to negotiate with the Sabha. Thank you.
So parties, we have taken note of your agendas. There is just one question to the responding party. Would you like to stick to the agendas suggested by the requesting party or any change, addition, alteration?
Permission of the the requesting party here. Can we club the termination of 120 members with job security, that is issue number 3, and proceed with wages and overtime payment as issue number 1, job security and the termination as issue number 2, and grievance redressal as issue number 3. That will concise us to 3 issues. Also, we can address the concerns of the existing champions in the company working and at strike first, that is wages and overtime payment, and then we can come to the 120 people who have been, due to other reasons, let go. That's it.
Is that okay with the requesting party?
My client have put the request to me and to the requesting to the responding party. My client wants to discuss the termination, and as suggested, we could club job security with termination. So we are agreeing with it. We can club termination and job security in a single agenda. So we can go first as the termination and the job security, and secondly, we can incorporate what we will say, wages and overtime, and thirdly, with the grievance redressal.
My question to the responding parties, would you be willing to compromise in such a way that they discuss the job security matter first in lieu to the retrenchment matter? Following that, you discuss the wages and compensation?
Sure. But let us keep it brief because we really have to address the concerns of the champions at strike. They are our priority, right?
Definitely, we understand. In fact, Mr. Shayar as well, it's a strong suggestion from the conciliators that since you still have delivery personnel working under you, there are still delivery persons who are working under ACPA, correct? So you also have to protect their interests. So in lieu of that, make your decision.
Noted parties, please note down your agenda number 1 will be termination coupled with job security. Agenda number 2 will be discussion on wages and overtime payment of the gig workers or the champions present currently in the job. And your third issue or agenda is a mechanism for grievance redressal. Is this noted on? Okay.
Keeping in mind again the paucity of time, us as conciliators have decided that let us, for starting off, give 10 minutes per issue. So there are 3 issues at hand. In an ascending order, we'll be providing 10 minutes for each issue. Kindly stick to the time total. All right. Thank you very much. The requesting party may begin with the first issue.
This conciliator payment, the main contention from our side.
Please speak loud. Speak loud.
The main contention from our side is the termination of 120 employees. Like they consider us as a champions, and they even said that we are a part of their family. But what happened when they are terminating 120 champions? Who named that? Because of that 120, because of the champions, only the profits of the company is being gained. What we would like to say that they just over a call without giving any sort of notice or anything. Just over a call, over a phone call, like a Zoom call, it's a meeting. They just terminated them. Or like we treated the CEO Dhanyavad as our god, and he just terminated 120 employees. And our contention was they are on roads now. Seeing them on roads, like their family is also getting affected. Even if you see, there can be wives of that delivery person as well as children of 3 or 4 years. There might be a chance of their life has been affected. Their family's lives has been affecting, as well as the health of that small children are being affecting. With that being said, something like that.
Client rightly pointed out, first of all, the issue that he raised, the termination. I agree that company has full right to terminate its employees. But one sudden day, a Zoom call meeting just coming into a picture, and the company asked 120 members join that Zoom call meeting, and they turned the Zoom call meeting at the first hand appraisal and team management. And when 120 members joined the Zoom call meeting, in the Zoom call meeting, they terminated all 120 members without giving a valid notice, without giving a valid reason. They don't even know how and why they were terminated.
Indeed, Mr. Counsel, sorry to interrupt, but I think the same has already been highlighted by Mr. Shayad. If you could quickly lay down the expectations that you have from the other party with respect to not just the retrenchment, but also considering the right of current delivery personnel, job security, and layoffs. Your expectations.
Thank you, Madam Conciliator. Firstly, I would like to highlight those who are currently working. They are under fear because they don't have any job security. They are fearing that they can be terminated at any point of time. And that is a very main concern. And first of all, what we want from this conciliation session is that we want those 120 members who have been terminated by Mr. Dhanyavad, saying that his company is undergoing a financial distress, have to be reinstated again back into the company. And moreover, when they are reinstated back into their company, they have to make a clear policy regarding job security, where the notice period have to be explicitly mentioned that before terminating or before giving any retrenchment or layoff, they have to give a 45 days of notice period before terminating. And secondly, we want a severance package also into the policy. Because whenever they are terminating, those employees, I would like to highlight 120 employees, most of them are not being able to get the jobs. They are low pay package, they are working in low package wages, and their families are suffering. If they would have given the severance pay, they would have been able to sustain. That is what our demands is.
Noted party, that is taken on record. Just in short, they are asking for, the requesting party is demanding for reinstatement of 120 terminated champions, along with a policy that is clear on job security, with a notice period, if next time there is termination, with a notice period of 45 days and a severance package. Now you can put forward your counter demand or any other offer.
Before that, can I get a clarification? Mr. Gupta mentioned that these people were not made aware of the reason why they are asked to leave. I want to know if that is not, if the reason has not been made aware to the council here, because the champions who have been let go off, personally, Ms. Dhanya has spoken to them and she'll elaborate on this more. And so far, so the concept, the idea of job security, severance pay and a 45-day notice goes, we are open to negotiate on that. But first, please lend a ear to my client.
Clarify. Because I was saying,
Mr. Gupta, you will be given a due share of time. Kindly let her client speak, right? And then I will be providing time. So the fact that you have to speak has been taken into consideration. Thank you.
Well, I feel more than privileged because Mr. Saha has called me, has referred to me as God twice. So yes. So I just wanted to tell you that I did not terminated the gig workers. I still want to keep them on board. I wanted to keep them on board, but due to the financial constraint my company is facing, I want to cut my operational expenses. And that was the sole reason that I took this unfortunate decision. And even after so many years of experience, I've worked in previous companies as well. And this company I started back in 2020. I still don't have that exact method, how to crack it, how to be profitable still. My EBITDA is still in losses. So I'm still trying to crack it. So that was the sole reason.
And so far, so the reinstatement goes as my client, which is why I wanted to listen to it from your board itself. He wants you on board. He cannot have you because there is no money to keep you on board. So we cannot go ahead and talk about reinstatement.
Noted party. But we would just like to clarify about the other terms because they have set forth 4 demands. And maybe you can answer, since you're ready to negotiate with one hand on the guitar. So you can tell your counter demands and later the stage is up to you both to decide.
So I think we can go ahead and as my client had decided with the board of directors with maximum 30 days or 15 days, I am going to extend it to 30. The board of directors still wanted a 15 days notice period. Once they put a cost and a finance on the severance pay, we can go ahead and have a negotiation, but no reinstatement.
As promised, Mr. Gupta, kindly provide the clarification that you had to provide. Please limit yourself to the clarification.
clarification was just that only. Those 120 workers who were terminated. As Mrs. Council already stated that in the meeting, Mr. Klein told them that company will undergoing financial distress. But why only those 120 members? They don't know how, on what factors they were selected. That was my main concern. And again, like I'm very much appreciating Mrs. Council that she agreed for a 30 days notice period. That will be like this with the permission of my client, whatever he feels, whether
Yes, Mr. Gupta. The clarification has been provided, I hope. Ms. Arya, is the clarification provided? All right. Now, I'll ask my co-conciliator to take it.
There is just a small question. So, is the requesting party okay with the 30 period notice time? 30 days notice period?
Yeah, we are okay. 30 days.
The 30 days notice period is okay with the responding party?
If they are unable to provide 30 days notice period to the champions, they should pay the severance pay which they are earning in the previous month.
This is from the coming time. For the existing champions who are in your
Yeah,
company,
this is for the existing champions. And
No,
champions who are already terminated, the severance pay will be negotiated.
Can you put the number on?
yes, maybe you can give a number. That is what.
Regarding the severance pay, we either pay the severance pay or we'll be providing the 30 days notice. Is that fine?
Let me summarize the offer. Like we are saying, it's a 30 days notice period to a champion. If you are going to terminate anyone, you need to give a 30 days notice period. If you are not able to give the 30 days notice period, you are terminating them immediately. Whatever in the previous 30 days they have earned, including of all bonuses and everything, pay them off.
Okay, just to clarify the stance, this is for the existing members. So
Yeah.
existing champions,
Yeah.
if they are not given a notice period, then you would have to give a
And
sentence.
my client would like to clarify why those 120 people were chosen.
See, 120 were chosen based on this, and as per the said gig sector economy, we are very open, and this is a very general practice to terminate the employee. We are not required to give them any sort of notice, and that was clearly mentioned in the contract of employment as well, that was signed between both the parties. We are not required. We can terminate you at any point of time.
And the whole reason, there was no performance review, there was no customer review, because that is not how we can decide our finances. For instance, it's a pan-India application, right? Wherever we are falling short of funds, that geography is suffering a layoff. That is all. And the point where bonuses along with the payment is being asked for, I humbly request panel conciliators to please convey to the respected party that there is no money, which is why we could not keep you on. The party is now here asking for the revenue as salary, which actually has never come to the pockets of the company. For instance, if you as a champion leave the company, the revenue also goes. Then how are we supposed to give it back to you? I think the severance pay should be based on the average fixed fee that they any which way get, which is 2,500 into 10,000. Sorry.
Noted party. As the conciliator, we were about to suggest the same thing. I would like to ask the requesting party to kindly consider and be in view of their financial status right now. So since they are having a financial downturn, maybe for now, the severance package, if there is no notice period of 30 days, can be 2,500 into 4, because 2,500, that is weekly. That would amount up to 10,000. That is what the party said. So 10,000 severance package if they are not notified. Is this offer okay?
Conciliator, we just want to say that in a city like Bangalore, 10,000 is not all like sufficient to stay for a minimum life. And at least like their company status is not in a financial their company is at a financial distress right now. We are asking this bonuses and everything for the future, not at present, right? And we are asking this bonus and all because if the champion has not been terminated, you would have earned all the bonuses, right? So this was a basic requirement for even for a low skill for people like us champions who have very low skill. It's very hard to find a job in Bangalore. That's what being said and
Taken on record parties that they are telling in future. Again, this is up to you.
Consider. So they do not want to budge on the bonus aspect. I just want to let them know that as a company, as they said, in a city like Bangalore, we also want to say in a company like ACPL, which is running into losses, it won't be possible for us also to budge on the bonus aspect. However, we are still refraining ourselves from setting a precedent. For example, we decide something here in Bangalore. What if people in Mumbai then again start revolting? What if Delhi starts revolting? We cannot set a precedent here. All right. This is any which way rather unprecedented in a gig economy sector. Another thing is, according to the clarifications, each and every champion was getting a fixed fee of 10K any day. They were only getting bonuses if they meet the 65 order mark, and that was not the case with each and every champion. Only some exceptional people were meeting that criteria.
Just a moment, Ms. Council. Taking the discussion back to where it started from, pertaining to the amount that was decided, provided that the ACPL does not provide a 30-day notice period to the employees, I would like both parties to discuss upon that. Right? What is the amount that you are willing to pay, since this particular party stated that they want a severance pay of the previous month, right? For those people. But you are saying that that is not possible owing to the financial constraints.
When they say previous month, all they are saying is 10K fixed fee plus the bonus that they earned in the previous month.
Yes.
What they are saying is the bonus is not possible, the 10K.
That is taken into consideration party. Again, I request the requesting party to understand their financial consideration. Here, one solution as a conciliator, I would like to suggest, maybe for now, until the company regains back its financial status, we can have just the monthly fixed fee as the severance fee. After the company regains its financial status, then we can think about adding the bonus as well in the severance. Is that okay with the company? And this is for any champion that is terminated from now on.
At least, Madam Conciliator, we would like to say that at least right now, at least considering the financial stress of the company, we would like to offer at least 50% of the bonuses should be given right now, and give the company going forward. And it's a mutual respect that because of us, like everyone is doing like a boycott around the world, right? Even if the demands are met, then we will even market support Aramco, which will be beneficial to the company and which will be even helpful for the company to gain financially.
My client is emphasizing on it is that it's been the 4 months and most of those delivery partners who were just terminated, they are not being able to get the job. They are not being able to sustain their family. They are not being able to raise their children. And as per the confidential information which we have gathered, like the Mrs. Council of the responding party and Mr. Klein very effluently talked about the performance and board of directors. But as per the confidential information, the board of directors have moved against the CEO of the company, and they have directed the CEO to mitigate the losses and not to make any substantial threats to us. And moreover, board of directors, it is the direction of the board of directors that to coordinate with the trade union, and even the board of directors are in constant touch with my client, and they are constantly affirming us that the CEO, the client of the responding party will be able to reach to an amicable solution, and that is what we want from the responding party.
And Conciliator, we really want to address both the points that Mr. Yard has made as well as Mr. Gupta has made. First, as the council, I just want to address Mr. Yard. At this point, I think it is absolutely vindictive of the trade union to not budge from the bonus aspect. As you said, you need 2 hands to play a guitar. If you do not budge from the bonus aspect, you are cutting this hand off. Your guitar will be rendered useless. Number 1. Secondly, we have come from 0 to 10. As my client said, there is no industry standard in a gig work-based economy to even go ahead and make any such payments. My client would like to address through a private caucus the points that have been raised by Mr. Gupta. That is permitted by the
that is taken on record. Can the caucus happen after this issue has been
sure? But until then, Mr. Gupta should not raise any point pertaining to the board of directors.
Totally. Also, since we are facing a deadlock in the number 10 or above, we can discuss about that later, because right now notice period is discussed. So let's not keep on prolonging on the same thing. Right now, I request both the parties to talk about the reinstatement of the 120 members. That is not possible.
That was
1 minute, Mr. Shaya. Please take into consideration that this particular matter of retrenchment is an ancillary issue to the job security. Right? Discuss it accordingly. Discuss it according to the paucity of time. All right.
so. As listening from the CEO of the company that they are not ready to reinstate us back, the 120 employees back. So, like, what is the severance package that they want to give us? We would like to propose that from June to 12, 2024, right? Like, we would like to propose that 4 months has been elapsed. So, we want the severance package of 4 months. So, till now, we didn't get any
Just the weekly salary. Just the weekly salary fixed amount.
fixed amount. Yeah.
Madam Conciliator, is this going to be a logical discussion or is this going to be just latent demands, pointless demands? Can you believe as a human being, as a conciliator, if I ask you to pay, you're running into losses, you have no money in your pockets, 40,000 per 120 employees. What I meant by 10,000 was 10,000. That's it per 120 employees, one-time payment. That is not even the standard. My client is doing it out of goodwill. These people are now just being absolutely vindictive. I would like to call for a private caucus at this moment. There is no point going ahead and circling around 10K and 40K if nobody is ready to budge.
Madam
But
Conciliator,
please,
just-
one second. We see why you are agitated, but let us just, please maintain our cool and decorum, and I think we can.
I think,
Before private caucus, like she talks about humanitarian ground, it is my client who is paying those 120 employees and that who got terminated. From then onwards, who's paying for them? That is my client. From his own pockets, he is paying for those 120 terminated employees. It was nothing from the CEO.
Mr. Counsel, just a moment. You come from a legal background. It happens. We are also conciliation officers. We understand that financial strain upon a company is not a small thing. My mere suggestion would be, I completely understand the emotions of Mr. Shayar, but do take into consideration what is the capacity of the next party, right? Only in accordance to that will you be able to come to a consensus.
Maybe you can revisit your terms by the time we have the
Just
caucus.
confirm one thing that the thing of 10,000 which we are discussing, that was in future and in furtherance, not with the terminated employees. We told that it's
That is
very
noted.
clear.
That is noted.
They told that they are
Like
paying.
40,000.
No, we said that 10,000. They are saying that we discussed 10,000, which is like 120 employees to fix that one. That 10,000 we are discussing for the further employees if they are going to terminate us. Not for the terminated employees. We never discuss about terminated employees
Could I
at any
just
point of time.
provide a clarification?
Yeah, they
for
are
the-
providing a clarification.
Yes, I'll just provide a clarification for the benefit of both parties. When Mr. Shayad was talking about the 10,000, let's not use the word severance pay in that regard. When he is talking about the amount of 10,000 rupees, what he's trying to say fair and square is that basically in the future, if your company retrenches any employee, lays off any employee without a 30-day notice period, then you will have to provide them with a severance pay of, not a severance pay, an amount of 10,000.
That would be severance pay. True.
Yes,
Is that
yes.
clarified?
Very well. But for the future, but for the terminated employees, those 120 employees, for them also we cannot pay more than 10K.
Noted. But I just
40K would be too much to ask. I want to pose a question to Mr. Jai Gupta. How is it possible that from the last 5 months, none of those 120 employees were able to get a job? Not even a single one got a job. Did we tie your hands?
Mr. Client, I never said that none of them are being able to get the job. I said most of them are not being able to get the job. There are some who got.
Yeah, just said.
both parties please consider the decorum of today's proceedings, address each other through the bill. All right?
Yeah, just mentioned that they have been suffering for 5 months and he has been singing and playing this harmonium for around 30 minutes, I believe. But the point is, the only requirement that you need to be registered on a platform like Swiggy, Zomato, Instamart, Uber, Ola, Rapido is that you need to have a driving license and you need to drive. If you were on our platform on these grounds, how is it that around 15 different players also could not do anything about it? You could not get a job there. And Madam Conciliator, just to put an end to this, my client, out of his goodwill, once again, even though being betrayed absolutely by Mr. Yad here, has told me about a referral system that he'll be proceeding with. Just give him 30 seconds to put this forward. If they agree, we go ahead.
All right.
Yeah, so if I don't know the number of employees who haven't got the job yet since the 5 months, I don't know how is it possible. 5 months is a long, long time. So yes, I would like to suggest a committee that I will be personally forming and I'll be personally heading, that I'll be forming within the company, and only the trusted employees of mine will be taking charge of it. They will, what they'll do, they'll contact Mr. Shah and they will try to refer those employees who have been terminated by us to other companies, so that they can get laid in another company maybe. That is our proposal.
First of all, this is Conciliation client. Those trade union workers are now MD graduates that they will be getting to know how after just got terminated. They are just low-paid workers. You cannot say go that way and that way. And first of all, whatever you have suggested about that committee, we would like to talk about that committee structure. Like what members, like how much the representation would be from your side.
I would suggest both parties, as we have already set the agenda, this comes under the agenda of a sort of redressal mechanism, right?
That is what I wanted to clarify. This is not a redressal mechanism committee. It's a placement committee for job security for those 120 people. Because they are not ready to budge from the concept of 10,000 and 40,000 and we have nothing in our pockets.
Just want to confirm one thing from the same. Is that you are saying that you will be referring us to the other companies, right?
Yes.
Is that, are you guaranteeing the 120 employees a job?
See, I cannot guarantee jobs. That is not possible for my side. What I can guarantee is we can decide the structure of the committee here itself and we can move ahead with it. And I'll be personally heading the committee, and the head of the committee itself will be in contact with you personally. That I can assure.
Thank you. Mr. Shah, just keep into consideration. I believe your counsel will be able to explain to you better the suggestion provided by them. It is, I mean, since it's another company that they will be referring you to, it is not completely in their hand. My suggestion is take that into consideration, knowing the bounds of assurance. Now, I would request for the party that is requested as a responding party to proceed for a private caucus session if it's okay by both. Is that all right?
We request the moderator to escort the requesting party out.
Kindly note that this private caucus session will be for a limited period of time, that is 3.5 minutes. There will be certain additions provided there any further concerns raised by party.
Parties, just before you begin, please know that again this private caucus session as well is confidential and we will not reveal anything to the requesting party unless you give us the green signal. May I address your concerns? You'll have 3.5 minutes.
Thank you so much. So, since the conciliators are considered to be the epitome of maintaining the confidentiality, I would like to raise up certain points and I do not want it to be disclosed to the other party. Thank you.
That is taken on it.
Thank you so much. See, the board of directors of my company is not on my side. There was a previous mutiny that have been moved against me by the board of directors itself. And I, from my side, I have tried to issue a memo to them to not to do such activities or actions could be taken. Yet there was not much effect of that. I'm at a very weak position right now. Allegations such as corporate espionage have been also made against me. Can you believe it? What have I done wrong? And why? All of this because the rival companies in my sector, who meet the on-demand delivery sectors, they have been made aware of the various features and deals. And who have made them aware? None of them but the champion workers itself, the trade union itself.
Yes, sir.
Yes.
The rule book was provided that the private caucus is between one party and the conciliating party.
Then they are sent out of the room, and then next they will be sent out of the room.
Between conciliators and confidential. Okay.
Yes.
Can we proceed? Thank you.
Thank you, judges. So yes, at last I would just like to state that I am not the villain over here. I consider the champions as my family and I will prove it in the future. But at least tell them that their demands should be reasonable. Asking 40K as severance pay is not at all justified. So again, my council would like to put up certain proposals.
I'll just sum it up really quickly because there's no point going back and forth if we are having no discussion. I'll put up my suggestions to you, Madam Council. You with your wit, I'm giving you the liberty with the permission of my client. You with your wit and suggestions, please put these forth, henceforth what I say, to the opposing party. A non-disclosure agreement or a clause must be added in the memorandum of settlement today that anything beyond this will not be considered binding. My client will not be answerable to any communications which are happening with the trade union, which the trade union is having with any of the board members, because that has uncovered. We were just made aware that a board member is colluding with them behind Miss Vad's back, and for wages, maximum that we can do, with job security, the maximum that we can do is 10,000 henceforth or a 30-day settlement. Along with that, we can get 120, at least few of these people who have good ratings to get settled in other companies via the referral code system. There will be no reinstatement. Per se, the wages, I know we have not moved to the point, but I just want to clarify my demands to you, my suggestions to you. The maximum that we can give is a fixed fee. What we have in mind is reducing the cut of the company. For example, if any champion goes ahead and makes a delivery and receives 1,000 rupees on it, the champion will get a certain amount, a certain percentage, which will not be meager, it will be a significant percentage, and we will get a smaller cut. We will continue to run into losses, but at least the champions will be on our side. So that way, just one more second. Yes. So that way, even by making 60 to 65 deliveries, they can go ahead and make more than the fixed fee, which is instead of making 2,500 a month, 2,500 a week, they can make 3,000 a week. And we are also proposing to have a labor fund in case all such contingencies about money arise any time in the further.
If that is taken on record, we will put the wages aspect to them when we come to the wages agenda. And secondly, it is obvious, once the memorandum of settlement is signed, we will put NDA as a clause. But once it is signed, it is definitely binding on the parties. As a council, you are aware, it is having an effect of an arbitral award. So that will definitely be binding. Is there anything else you want to say? Or
we specifically mentions that no board member will be able to collude with them. They will not be able to do the same, and nothing will be questioned to my client in the board meetings on the basis of those conversations.
That is taken. Can we call the please?
Sure.
Yes,
Please proceed on.
in order to maintain equity, we have to give chance.
Welcome, Mr. Shaya.
Thank you, Conciliator. We know whatever they would have told.
Hope your break was good. They have proposed some suggestions and solutions and demands, which my co-conciliator will relay back to you.
First of all, again, let me inform you that whatever you discuss within this private caucus session, we will not be telling them any of it. It is on the basis of your consent, right? So if you do not consent to it, we will not be telling them anything that is discussed between us. Now, after listening to them, actually, we have come to understand what are the major concerns that them as a company have in respect to providing you with your demands, right? So we have a little clear understanding. And with regard to that, Madam Council has provided certain suggestions to the party. I'd like to set out the suggestions before you so that you can let us know what are your
Suggestions, Madam Conciliator.
Hello, please speak loudly. We are unable to hear it.
Board of Directors himself told us that his company, their company is going to this. But whatever the suggestion we have given, we have already pointed out to the Board of Directors, and they are in constant touch with us. But even after that, the same suggestions which we are proposing to the responding party, they are not being able to.
Mr. Council.
One more thing, let me add here. When we are in connection with the board of directors, I don't know why the CEO is going against the board of directors' decision to reinstate 120 employees, which was already decided by board of directors in the meeting. I don't know why, like That was the main contention that the CEO is going
Mr.
to.
Shayad, just a moment, sorry to interrupt you, but here we're in a conciliation setting.
Yeah,
So it is, both the parties have to negotiate in a way that yes, it is also beneficial for Mr. Dhanyavad, it's also beneficial for Mr. Shayad, all right?
Yeah.
In lieu of the same itself and taking your considerations into mind, I want to just relay the suggestions that they have put. Maybe they might be beneficial for your understanding. Kindly just let me do that. First of all, they have spoken about the fact that they are agreeing to the 30-day notice period that is to be provided to any delivery personnel before terminating them. And provided that they cannot provide such a 30-day notice period, they'll be giving a severance pay of 10K, right, which is 10,000 rupees to each delivery person. Further on, they have again reiterated about their referral code system, whereby the employees who were laid off, they will be provided, they will try to provide other sort of employments in other companies through referral code. So, for example, an employee has got great ratings, right? So their chances to get employment in some other country, it increases. All right.
But the problem with this is conciliator.
Kindly,
Yes, we are just putting forward the solutions that they propose. You can negotiate the solutions with them later. I hope that's clear. And please put your mic a little higher when you do.
this is merely suggestions put by them. So you have to negotiate with them with respect to it. Secondly, they have said with the matter of fixed fee, right? They have come to the point of wages. We will be discussing wages further on, as my Madam Co-Conciliator also clarified, but just to put it for the interest of the party, what they have suggested is that the company gets a particular kind of cut from the weekly deliveries that you make. They are willing to give up on that, a portion of that cut, so that the delivery personnel's wages increase from 2,500 to an amount of 3,000. Furthermore, another thing that they have said that nothing which is settled here today is to be nothing that has been discussed between you and the board of directors is to be made binding upon them upon any kind of settlement which is made today. So anything you speak with them in regard to whatever concerns that you have, that will not be binding upon the respondent.
Like just in addition of this point, in clear-cut terms, they are requesting for a non-disclosure agreement, in which you will sign stating that you will not collude with any of the board of directors, because theirs is a completely managerial aspect as compared to yours, correct? We all agree on that. So they're just requesting you to sign an NDA agreement that you will not collude with any of them, and you cannot question the client on the basis of that whatever is spoken today in front of any of them.
First of all, why not?
Just a moment, one last suggestion that was put forth by them was regarding setting up of a labor fund. All right, they will be elaborating upon the same labor. Now, kindly relay your concerns.
First of all, why non-disclosure agreement comes into the picture? Because the board of directors put it into the memorandum of the company. Then what is the need of signing us the
Mr. Counsel, you can negotiate this with them when they are here. Right now, what I want to know from you, if I may put it so roughly, is I want to know what are the points you're willing to compromise upon, what are the points you do not want to divulge upon, and is there any confidential thing you want to share with us?
First of all, I'm glad that they have agreed for 30-day notice period. And secondly, they have also agreed for severance pay, which I can see. And they have suggested us and they have made a proposal to us for referral payoffs. And again, for referral, I would like to suggest to you, Conciliator, to them, that there are many government policies who are there for gig workers who got terminated.
So sorry for the interruption, party, but are you okay to talk this in front of them?
Yeah.
Can you directly speak? Then we can call them and you can relay your concerns directly to them and you can negotiate. Or if it is confidential, you can tell us.
It's not confidential, but before relying to them, we want to.
No, okay, please lay them.
So, as I was discussing with my client, so I suggested there are many government schemes that are there for gig workers and those who are being terminated, who are not being able to get a job. What I was suggesting is, if the company can take the stand and make sure that if those employees who are not terminated and they take the responsibility that they get away those government services and government schemes under government schemes, then I feel it would be very beneficial because the burden would be shifted from the company to the government. Because those schemes that are being laid off by the government is for the benefit of the workers, for the workers who are not terminated. So they will be just shifting the burden to the government.
For a small clarification, if I may ask, pertaining to this point, are you suggesting that the company assure the fact that these particular delivery personnel get under some sort of a government scheme?
Yes, because the e-service portal is there. Because what I am suggesting is the company takes a stand, whatever the delivery partners who are there working into the company, they avail, they are registered into the government scheme, even if they are terminating those.
Understood. A small consideration also suggestion that I hope the council and the client knows that even if they want to relay these terminated employees through a government scheme, they cannot assure that either. Just as they cannot assure employment through a referral code because it depends on the other company, they cannot assure 100% that all the delivery personnel will be employed under that particular government scheme. You have taken that due into consideration, right?
As I said, so we have one more candidate proposal to go at hand. Because what I am suggesting is, the company should make a fund, a collective fund, where the company will be.
Mr. Council, they have already suggested formation of a fund. So if there is something you want to discuss with them, we'll just now like to invite them. Ms. Moderator, you kindly call the other party.
Also, please keep note of the time. We are left with 15 odd minutes from now on. So we would like the parties, we are left with, how was your break? Okay, so we are left with around 15 odd minutes from now. We can quickly wrap up termination and job security and maybe discuss a little on the overtime payment and GRC mechanism. So would you like, yes, would you like to? Okay, yeah, in the meanwhile, I would like to state certain points they want us to put forward to you. Both the parties, I can see we are going somewhere. First of all, a pat on your back. We are not very stagnant, but we are making some progress. They also suggested a same fund, just like you, but only request is there will be parties from both sides. Correct? If I may. Okay. So I will lay down the terms one by one, and you can tell yes or no. So that it will quicken the process, and we will know. And Madam Conciliator, please take note of the same. So there will be a labor fund from which there will be representatives from both sides. Contribution from both sides.
We need something that the company would at least do 2-3% of the profit to the labor fund.
Yes, we are okay with that.
Okay, noted. So
Just a moment, Ms. Council. For the clarification of the conciliator as well as the party, since you just mentioned the term labor fund, could you in 30 seconds just provide a gist of what this labor fund would do?
I'll just take 10 seconds. It's going to be a fund which is for the existing employees, the existing gig workers, the champions, and they can use it in contingent situations. Even though we provide bonuses for situations like death anniversaries, marriage, etc. But this is to go ahead because I heard the concerns that my client really suggested that they're not able to make their ends meet. That's
noted. That is what they also have suggested. I can see both of you are coming at least 1 point from the same background. The second thing, it is something in lieu of your placement committee or the referral code that you are referring to. They are okay with the idea, but a small suggestion is that, as we all know, you cannot guarantee the job, but they are requesting or in fact suggesting you to take into the factor of the consideration of government schemes. There are several government, that's what they are suggesting, the council has rightly pointed out, there are several government schemes and portals which, tries to provide job for gig workers.
is aware of this actually.
Yes.
Yeah, that is one of the great ideas raised by the council and Mr. Shayad. And I would be more than happy to provide any sort of workshops that would be required for you and the champion workers in order to enroll yourselves for these schemes that you're talking about. Thank you.
That's all. And
Okay. Is any concern left?
like these, we are okay with that referral code system as well as they will be helping us in registering for the government scheme along with the severance pay of 10,000.
Yes, that 10,000 per worker is for the existing one. Already terminated 10,000.
Mr. Shayad, just a moment. For your clarification, I'm reiterating this. The 10K severance pay that is talked about is when they are failing to provide a 30-day notice period.
Let me clarify what I'm saying. They said what the other party is wishing to say that from next time on.
But you not speak for the other party. You can tell me what you've understood from what they've said.
Please let us know what you want. Do you want it for the 120 laid off employees? We cannot give that. We can give it for further the prospect everybody who has been laid off without a notice period. That is, I believe, very clear. We're not.
There should be something there should be something for the champion who for the creator, right?
That is the.
Please maintain the decorum of the proceedings.
They are on roads 4 months.
We understand the emotions behind it. We understand that. Miss Council,
We are 10,000.
one moment. Miss Council, are you willing to provide or negotiate upon a severance package for the employees who were laid off by your company?
Absolutely not.
Not?
Also, one thing, Madam Conciliator, let us not go around on this topic more and more. We have provided for the job security of the existing employees. We cannot do anything about the layoff. We have made suggestions, but they are not accepting it. There's a placement cell for that. I just want to clarify.
Keeping
I
this.
would like to choose one more proposal as they have already, with the permission of my clients, if they are not being able to pay the severance package to those terminated employees, at least as they agree that they will be taking the responsibility that those government schemes could be given to those terminated employees, all the employees delivery partners that are working in their company. So just if they can take the responsibility for those 120 terminated employees and get them registered or away from the government schemes.
Okay, once again, just to clarify, maybe you are not in clear terms asking for an assurance, but until the time they get a work, you will have to help them gain a job because they're big
We are
workers.
helping them in 2 ways, not beating around the bush anymore.
Noted.
These people will be given help from our placement cell, which will be coordinated by Mr. Shah and Miss Wag both, and constant communication with Mr. Shah will be made. People will be referred to other companies. Possible statements will be made in other companies. Secondly, they can also attend the workshop and get enrolled in these government schemes.
Yes, this includes the government because a small responsibility is vested on the companies.
Absolutely.
This is primarily because they're gig workers and they're not very educated as the council
This is
rightly
only
pointed
for the
out.
120 people. That
It's only for the 120 people. Is that okay?
Yes.
Can we move
Okay,
fast?
yes, we have less than. Yes, madam.
Continuing with how the discussions have been proceeding, I think we have come to some sort of a consensus regarding these two. Very quickly, I would like for both parties to settle one issue, which is the grievance redressal mechanism. Because of paucity of time, this is the issue that both of us conciliators have decided both parties should proceed with. Requesting party.
And just the second party, we are very aware that right now there is no such mechanism. So kindly propose solution because the facts on the table are clear. We would like to propose, like to hear to give offers and counter offers. You can begin.
I guess we are hearing the proposal. I guess my council will be in a better position to help you understand the proposal.
I, along with my client and various members of the trade union, have come up with a proposal that to be given to the responding party. So what we are suggesting is a smart GRC system. So smart GRC system works upon S stands for stepwise, M stands for mechanized, A stands for accuracy, and R stands for reliability, and T stands for time bound. So what we are suggesting in the Grievance Redressal Committee, there should be equal representation from the requesting party, the trade union members, and the responding party, that is the ACCL company. And there should be a proper voting system that has to be placed in discussing all the relevant and the important issues that are being raised in the company. And moreover, what we are suggesting, a ballot box. There should be a ballot box because when I was discussing with the trade union members, they were quite fearful, they were quite afraid that if they will raise concerns against the top management, we will face the consequences. So they are the mechanism can follow and mechanism. What we are suggesting a ballot box. In that ballot box, all the members of the trade union or all the big workers that are employed into the company, if they are facing any grievance or any issue, they can just make use of those ballot box. And in the GRC, which we have proposed, that ballot box can be discussed and the proper grievances that have been.
Understood. So a balance box and your smart grievance redressal mechanism, correct?
Okay. Thank you, Madam Conciliator. Just to put in short, I hope the party is ready to accept most of it. Maybe you can tell me a yes or no. after which you can give your explanation as well. So they are proposing a smart grievance redressal mechanism, which will be stepwise. It will use, it will be reliable and time bound. That I hope is okay.
So we get into the specifics of this.
Yeah, I'm coming to the specific. Here, there will be equal representation from both the parties in the grievance redressal. So someone from the management and someone from the trade union parties, please note we have 5 minutes. We'll finish this issue and then maybe proceed to the closing statements because they're very important. Okay, so equal representation agreed upon. Very good. A voting system. Okay, we will deliberate upon that further. After which, an anonymous ballot box. This will include anonymity because they are scared their concerns. If they raise their concerns, they might be terminated. And this ballot box can be, checked at a weekly basis or something. And those grievances can be discussed in the committee.
We have a better suggestion than the ballot system. A toll-free number that will be accessible 24/7. No one can go to the ballot box and post their concerns every time they face. Rather, we propose a toll-free number that they can call into anytime they like. It will be available for them 24/7. And someone from our company will be picking up the call and will be addressing their concerns.
Just one moment.
Just so far as the structure goes, we can have 2 people from the company, we can have 2 people from the union and 1 neutral party. We're completely fine with it.
A small suggestion to Mr. Shayad and council would be, since they're proposing a toll-free helpline number, it could be a 24/7 working helpline. So it would not just be for any concerns with respect to ACPI that they're putting in, but also if there's any sort of an emergency or an accident which has happened with respect to a delivery personnel, or there is any issue of security or safety of a delivery woman, they can also relay that through that particular toll-free number. Is that all right?
We completely agree with that toll-free number and we welcome that with the permission of my client. But the question is, with the toll-free number, the anonymity will not be there. So if ballot box system could be adopted along with toll-free number, which I think gives the more chance to the workers to put their grievances.
Will the workers be okay with reporting to the company every day and putting their suggestions because they don't work at a company? Plus the toll-free number will be outsourced any which way. We will not have the records.
So, Mr. Council, what they're trying to say is, this is with respect to the practicality. Like, will the delivery workers be able to go so on and so forth back and forth to the company to put certain suggestions within the ballot?
But we welcome that. We are asking for support.
We understand that.
Have a ballot as well as the toll-free number.
But are you saying it would be convenient for the workers?
I don't consider now at this point after 75 minutes they realize that it's either their way or the highway. So fine, if they want both, let them be answerable to the union. But why they have to come to the company every day, the company headquarters every day, and fix that.
No, just to one.
So we accept all their concerns about the grievance redressal mechanism.
Okay, but we have reached a consensus. Actually, we would like to clearly state again that there is no bias. We are trying to reach a balanced and a fair outcome that is equal to both of the parties. As you suggested, we can integrate the toll-free number, and whichever party is ready to go beyond and further to the company and post ballot box, I don't think that would be a difficulty on the part of the company. Parties, we have a little less than 5 minutes. I would request everyone to please proceed with their closing statements. Keep it short to 30 minutes. Sorry, I am so sorry. 75 minutes, that's good. 30 seconds per table. And yes, you may go. Requesting party, responding party, and then the conciliators will close 30 seconds.
So the main objective of conciliation lies in reaching a solution, to which I think for our trade union members we have reached. And moreover, thank you to the responding party, and I would like to extend my heartfelt thanks to both the conciliators and also to my client, Mr. Sahaya, who took the responsibility for those trade union members. And I think this was a huge success, and this conciliation, I think, a boosting point for those delivery partners and the charities.
Thank you.
First of all, I would like to thank the CEO and his council and for hearing us what our grievances are and agreeing to what comes to immediately and amicable solution to both of us. So we have not discussed analysis in all the issues, but we hope in future sessions we will reach some sort of amicable solution, amicable solution, so that it will be a sort of we will be able to work for you and gain more and more profits for our company, and we will be able to even get more bonuses as well. And I would like to thank all the conciliators now for facilitating this discussion to reach an amicable solution. Thank you.
You may proceed.
Nonetheless, I thank both of you and I thank both of you as well. Please forgive me in advance if I ever overstep my boundary or I overstep on your toes. And after my client is done and within 10 seconds, I just want the conciliators for the clarity purposes to please list out everything that we have agreed upon in one line, including the labor, fund, etc. That's it.
If time permits, we will definitely try to start.
Thank you everyone here. Thank you for mutual respect of the party. I sincerely thank you for arriving at a conclusion, or I'll say partial conclusion. Rest assured that the company's interest will be always aligned with the needs of the company.
Kindly, 2 minutes. Much thank you. Okay, thank you, parties. Now we can discuss the final terms within 2 minutes, and then we will give our closing statements, and this session will come to us successfully.
So the final terms of settlement, we will just divide it among ourselves. Right, so I'll be dealing with the first part of it. Basically, what both the parties have consented to is the fact that to protect the job security and to ensure no arbitrary layoffs occur, the company will be providing a 30-day prior notice to any delivery person who is terminated. Provided that the company does not provide such a notice, then they will be giving them a severance package of 10,000. In addition to that, both parties have agreed that to ensure job security further, in respect to the employees who are not reinstated as of now, you'll be providing some sort of help on your end to, yes, as a placements as well, and also through government schemes to get them employed. Very quickly, my co-consultant will sum up the fact regarding the grievance redressal mechanism.
Okay, so as far as the next agenda, grievance redressal mechanism is considered. Here we have agreed, both the parties have mutually agreed to ensure a smart mechanism in which committee, there will be equal representation from both the parties. As already stated, 2 members from each party and 1/3 neutral member. There will be an anonymous ballot box along with a 24/7 free toll number. So parties, I thank and commend both of you for, along with the labor fund that will be assisted, correct? So parties, I thank both of you for coming here today, committing to this session and trying to explore an area out of court, that is an ADR mechanism. Throughout the session, I have witnessed genuine efforts from both the sides. Thank you for being open and being the 2 hands of the guitar. Please remember that communication is always the key. Thank you, parties. With that, we are done for the session.
If you are appreciating, appreciate. Thank you.